Go ahead, Kathy.
Okay, hi. Thank you for joining us on a Saturday. I'm sure everybody would like to be doing something more fun, but we appreciate your being here. We have quite a few people with us today. We appreciate Debbie helping us with this class. I want to tell you a little bit about Debbie. Debbie Driver grew up in Eureka, or maybe some people call it Yreka, California. It's up in Northern California. Started work as a legal secretary in the legal field in 1973. After many years working for civil attorney as a legal secretary and then as a paralegal, she operated her own business, Quality Document Preparation Center in Redding, on March 1st, 1998. Debbie has been a member of CALDA since 2002 and was a member of CAIP from 2000 to 2002. She's served on the board of directors for CALDA in the past and taught document preparation classes for unlawful detainers, guardianships, conservatorships, and probate at previous CALDA conferences. We thank Debbie for doing this for her Saturday. And Debbie, if you're ready,
yes,
you may start.
Yes. Well, welcome everybody. Thank you for joining us this morning. We have a unique opportunity here in not only in the state of California, but I guess the entire country. There's going to be an onslaught of evictions when we get through this pandemic, if the landlords haven't lost all their properties to foreclosure. So it is an opportunity for you to be of service. You want to keep in mind with regard to people representing themselves in court, if a corporation or a partnership or even an LLC contacts you and they want to evict somebody, those entities cannot represent themselves in a court of law. They must have a licensed attorney representing them. So the people you're going to be able to help are the individuals, the individual mom and pop type landlords that maybe have one or two rentals. And so let's get started. You were provided in the materials emailed to you exhibits 1, 2, and 3. So those are the exhibits that will be attached to our complaint for unlawful detainer. So you're going to want to have those. Hopefully you had a chance to print them out or can pull them up so you can look at them on your screen, because we are going to refer to them to fill out our documents. Now, in the best case scenario, I would have gotten filled out the unlawful detainer procedure list that was also part of the materials emailed to you. But it was one of those weeks where I just didn't have time to do that. So if you had a landlord come in, I would sit down and have them fill this out or fill it out with them to get all the information you need, and then you could use that to fill out your paperwork. But since we don't have the questionnaire filled out, we're going to take the information right from exhibits 1, 2, and 3. So the first document that I want you to have pulled up and ready to fill out with me is civil case cover sheet. That is CM010 of the Judicial Council forms. I don't know what programs you all use. I use CEB's Essential Forms, and there is a database in this program where I can fill out the information. And then all this information, every time I pull up one of the Judicial Council forms, gets filled into that form. So it saves that duplicate effort. So I've already filled in the information on my database, the name, address, and phone number of the plaintiff, and of course, whatever court you're filing in, and the names of the parties. And under the UD tab, we've got the property address of the rental that we're going to be evicting from, the monthly rent, the rent that was due at the time the 3-day notice was served, the date of the notice, and the date that notice expired. Your daily damages commencing from, which is determined by looking at your 3-day notice, which only asks for rent through July 31st. So damages would commence August 1st to capture that rent until the date of the judgment. And then your daily rental value, which is your monthly rent divided by 30. So going back to the civil case cover sheet, my program has filled in all this information, and all I have to fill in now is whether this is an unlimited or limited case. Rents in Northern California are not real expensive compared to Southern California, so I've never done an unlimited case for an unlawful detainer where the amount demanded in the prayer of the complaint exceeded $25,000. So in this case, and in most of your residential rental cases, it should be a limited case where the amount demanded is less than $25,000. Under number 1, we are going to select under unlawful detainer that this is a residential eviction. The case is not complex. In other words, there's not a large number of separately represented parties. There's not going to be a lot of discovery or motions or large number of witnesses. It's a simple case. The remedies sought, we are asking for past due rent, but we are also asking for non-monetary damages in that the plaintiff wants possession of the rental property back once the tenant's moved out. So that would be B. So in all cases, I would check A and B for the monetary damages and the non-monetary damages being return of possession of the rental property. In an unlawful detainer case, there is just one cause of action. So you type in 1. And of course, the case is not a class action suit. You fill in your date. And the name of your plaintiff. And that document's done, and you print it and save it. The very next document that we need to prepare is our summons. A summons for an unlawful detainer case is very different from a normal civil case. A normal civil case, the summons gives the defendants 30 days after they're served to go file a written answer with the court. In an unlawful detainer case, they only get 5 days. So you open up your summons, which is SUM number 130. And again, fill in your parties unless you have a program like mine that fills them in. Now, one thing that needs to be determined that I always get from the unlawful detainer questionnaire is, does the landlord believe there could be unnamed adults occupying the premises with the tenants? If the landlord is not sure, I tend to encourage them to serve the prejudgment claim of right to possession, which covers any and all unnamed adults who might be occupying the premises at the time this action is started. In this day and age of couch surfing and homelessness and things like that, it's cheap insurance is what I tell my landlords. For an extra service fee, when the sheriff goes to do the lockout, you can be assured the sheriff can kick everybody out, whether they're specifically named in the unlawful detainer complaint or not. So we always want to name does if we are serving a prejudgment claim of right to possession. And just for future reference, I'm going to from now on call that document a PJ for short. I'm going to put in my does. And then everything else is filled in for me on this. So I am not an unlawful detainer assistant, so I check no there. However, I do put my information on here as required by Business and Professions Code that I prepared this document. And then I'm going to print it and save it. So when my landlords come in, I've been doing this for so long, they come in, we fill out the questionnaire. I sit down at my computer there, back before the pandemic, sat across the desk from me. And I prepare all the documents I need them to sign that have to be filed with this case to get it to a judgment. That way they aren't having to constantly come back to my office. An unlawful detainer action is one of the fastest, is the fastest moving civil case in the courts. They have a 5-day summons. There's a code section that says if an answer is filed and we request a trial date, the court has to set that trial date and hold the trial within 20 days of that request. So fastest moving case in the civil courts. So I don't want my landlords to have to constantly be coming back. I prepare all the forms ahead of time. They sign them. When I get ready to file that form with the court, I insert the date, the case number, and I can file it without the landlord having to run back by my office to sign documents. So I always do it in all the documents at once there. So our next form will be our complaint. And one thing I forgot to say when we got started, if there's any questions as we go through these forms that I might be able to answer for you, please try to address those questions so they can be brought up before we move on to the next form. So the complaint's a very important form in your case. It tells the court what your case is. Putting in my information, so the court will return my documents to me after they're filed, and I'm in compliance with Business and Professions Code. So again, you've got your plaintiff's information, your court caption. We want to check that we have does 1 through 10 here. And this is our initial complaint. Great, my computer wants to do an update right now. Jurisdiction, we have to check all that apply here. So this is a limited civil case. And in my jurisdiction up here in Northern California, I never have an unlawful detainer that exceeds $10,000 in past due rent. One thing to keep in mind, if a landlord brings you in a 3-day notice to pay rent or quit, and it asks for more than 1 year in back rent, that is not a notice that can be sued on. There is something in the code sections, can't tell you where it's at, but you can only ask for up to 1 year back. So if they come in and they're like, got tenants who are 1.5 years behind, no, you can't sue for all that. You can only go back 1 year from the date of filing. That's all that applies there under jurisdiction. So we have our plaintiff, Tammy Agent. She alleges a cause of action against the defendant, Joe Tenant. Plaintiff, and in this case, it's always an individual over the age of 18 years old. I cannot prepare paperwork for a partnership or a corporation or any kind of legal entity that the law requires be represented only by a licensed attorney. But in this case, we have a property manager who signed the rental, entered into the rental agreement with the tenant, collected all the rents, and served prepared and served the 3-day notice to pay rent or quit. So in that case, I would check that plaintiff is the property manager. Defendant named above is in possession of the premises located at, and here you put the address for the rental. Be very, very careful. I've had landlords bring in 3-day notices, and I've just copied the information from that, only to find out at the end of the eviction that the zip code they used was incorrect. That could that could create a real problem in your eviction, because our sheriff here in Shasta County, if the writ of possession and the instructions to the sheriff to enforce that writ of possession have the wrong zip code, they will not do the lockout. So always, if you are not 100% positive of the zip code that's been used in the eviction notice, be it a 3-day or a 30-day or a 60-day, double check the zip code before you file your complaint to make sure the proper zip code's being used. It can cause a super long delay. Plaintiff's interest in the premises is, wait a minute, I did this wrong, number 2. Plaintiff's an individual. My apologies. Down here under 4 is where we put plaintiff's interest in the premises is as the property manager. And in most of my evictions, it would be as the owner, because it would be the owner coming into me. Then pull out your exhibit number 1, which was your agreement to rent or lease. And you want to look at what date that was signed. So go to page 4. And page 4 shows that the agreement was executed and entered into by the parties on July 27th, 2017. So that's the date you would type in here. On or about that date, defendant Joe Tennant agreed to rent the premises as a, then you have to determine what kind of tenancy it was. And on page 1, under paragraph 1, the boxes checks that it was for a month-to-month basis. So tenant agreed to rent the premises as a month-to-month tenancy. He agreed to pay rent of $650, which is shown in paragraph 2 on page 1 of the rental agreement. And that monthly payment was payable monthly on the 1st of the month, all in that same paragraph, on or before the 1st day of each month. The agreement is written, and in some instances, there may not be a written agreement. It's just a verbal agreement between the landlord and plaintiff, and you would check oral there. So in this case, the plaintiff or the written agreement was made with the plaintiff, who is our property manager, who, because she entered into the rental agreement with the tenant and because she collected the rents, gives her the authority. And again, I can't cite the code section for you, but there is a code section that says the property manager can serve as the plaintiff in those instances where they've entered into the rental agreement with the tenant and they collect the rents and they serve the eviction notices if the tenants aren't paying. Page 2 of the complaint, paragraph 6. So we're not going to deal with any of these now, but I want to talk about when those might come up. So in paragraph 6, there might be other defendants that were named in the eviction notice that moved in after this written rental agreement was signed. So this is where you would check C and indicate that they are subtenants or maybe other, a roommate, a spouse. You know, whatever you might know about the defendants that didn't enter into the agreement that moved in later with the named tenant. D would be if the agreement was changed. So these people moved in, or this person moved in 2017. It's quite possible there could have been a notice of change in rent since 3 years ago. So that is something you'd always want to make sure with the owner. And it might be a clue if they brought you an eviction notice they'd prepared that asked for more than $650 per month. It's like, okay. So that's one of the things that might cause you to check 6D. The agreement was changed because there was a notice of rental increase served. If there's a rental agreement, you need to attach a copy under 6E and label it Exhibit 1. So that's why you have the agreement to rent or lease that I sent you that's already labeled Exhibit 1. It will be attached as the first exhibit to this complaint. If the rental agreement has been lost or is not in the possession of the landlord or the landlord's employees or agents, you would deal with 6F. And check one of those boxes. The written agreement is not in the possession of the landlord or the landlord's employees or agents. Or you could check this action is solely for non-payment of rent. If a copy of the rental agreement is available, I always attach it, even if it is an action solely for the non-payment of rent. Not sure what that means by solely for non-payment of rent. Does that mean we're not asking for possession of the property back? I don't know. I'd have to go in and thoroughly read that code section that's cited there. And hopefully that would answer that question for me. But it doesn't come up for me. If it's available, I attach it. If they say it's been lost, I just check one and I move on. So 7A, we would check. Joe Tenant was served with the following notice on the same date and in the same manner. So in this case, we served a 3-day notice to pay rent or quit, which I just noticed has a egregious typo in it, in that the July rent that I put was $6,500 instead of $650. But that is a typo, so please correct that on your paper. The defendants failed to comply with the requirements of the notice. Within the 3-day period, they did not pay the full amount of rent due, which was $1,950. Under D, the notice always has to include an election of forfeiture. That's required by the code section. And then a copy of the notice must be attached and labeled as Exhibit 2. And if you ever have questions about these forms, don't hesitate to stop and read the code sections that are cited, sometimes within the body of the document, or sometimes they're just down at the bottom of the first page in the right-hand corner. Here, it's got code sections cited. So that's how you teach yourself. That's how you learn, not only by doing, but stopping and understanding what you're doing and why you're doing it. Okay, the notice is attached and labeled as Exhibit 2. Paragraph 8, how did we have the defendant served? I did provide you with Exhibit 3, but did not fill out how it was served by the process server. So now you may fill out that on July 30th, the process server personally handed a copy of that 3-day notice to Joe Tenant. So that was personally served, a copy on the defendant on July 30th, 2020. If the tenant was not there to be personally served, but someone else was there, the process server would, or sheriff would leave a copy of the notice, or the landlord can serve their own notices also. Just so you're aware of that. A landlord has a legal right to serve their own eviction notices. So they could leave a copy with whoever answered the door, as long as that person was of suitable age and discretion, i.e. A young adult. You wouldn't want to leave it with a 5-year-old child. That would not be somebody of suitable age and discretion. But again, that's getting into process serving. But that's where you would check if it was served by what they call substituted service. And the third option in serving here is if no one answers the door, or no one of a suitable age or discretion answers the door, the notice can be served by posting a copy on the premises, and you indicate the date it was posted, and mailing a copy to the defendant at the premises on, and also indicate the date that a copy was mailed here. And then you would have to indicate, because no person of suitable age or discretion can be found there. So in this case, none of those apply. It was personally served, but I wanted you to see how you would fill that out when it was served in different ways. I don't use 4 or 5 much. You can't serve a 3-day notice by sending a copy by certified or registered mail. So I don't even use 4 and 5 there. So I don't have much to say about those. I can tell you I've tried to use B before and saying if it was a jointly signed rental agreement, like between a husband and wife or something, and we only got one person served with the notice. I've tried to use that before, and our courts have here in Shasta County have said no. Every defendant has to be personally served or has to be individually served, and there has to be an individual proof of service of that notice for each tenant. So say Joe Tenant had Jane Tenant living with him. There would have to be a second proof of service showing how Jane Tenant was served with the eviction notice. So, and proof of service of the notice in item 7A, which is our 7A, our 3-day notice to pay rent or quit. The proof of service is attached and labeled as Exhibit 3. Page 3. In this case, we would check 10. At the time the 3-day notice to pay rent or quit was served, the amount of rent due was, and you take that from your 3-day notice, $1,950. The fair rental value of the premises is how much per day? I always just take the monthly rent and divide by 30 and come up with my daily rental value. I have never checked 12, even back when I worked for attorneys. I'm not aware courts, even though that's in the law, I've never seen that used ever. I also don't check 13, even if the written rental agreement provides for attorney's fees, because I'm not an attorney. And there's a whole special loop or hoop that attorneys have to jump through to get attorney's fees in these cases in Shasta County, which I'm not even familiar with anymore because I don't work for attorneys. But if you happen to live in an area where there is local rent control, I imagine 14 would come into play, but we have no rent control or eviction control ordinance in our county. So I don't know if anyone else has experience with that in their counties, but I've never checked 14 either. Then we go down to the prayer of the complaint, paragraph 17. What is plaintiff requesting? Possession of the premises. The cost incurred in this proceeding. So that's going to be your filing fees and your process server or sheriff fees. In this case, because it's on a 3-day notice to pay rent or quit, we're asking for the past due rent of $1,950. We're also asking for a forfeiture of the agreement, which was also stated in our 3-day notice. F, holdover damages. The daily rental value from August 1st, and again, go back and look at your 3-day notice. The 3-day notice asks for rent for May, June, and July. So that covers up through July 31st. So holdover damages, the daily rental value would commence then the next day, August 1st. For each day, the defendants remain in possession through the entry of judgment. And that's all I would check for 17. 18, number of pages attached. Count up the number of pages of all your exhibits, 1, 2, and 3, and enter that here. So we've got a 4-page rental agreement and 2 pages for the notice and proof. So we got 6 pages attached. I am not registered and bonded as an unlawful detainer assistant, so I checked did not here. However, if you were registered and bonded as an unlawful detainer assistant, you would check did and fill this information out. And then we date it. Signature of plaintiff or attorney. So we're having the plaintiff sign there. And the complaint must be verified. Okay, I'm going to stop there. Are there any questions on that form? That would be a no.
Yes, there are several questions.
Oh, okay, good.
Yeah.
Not everybody falling asleep.
Kathy, did you want to go ahead and ask those? Well, she may be having some trouble with her audio.
Okay.
And I will go ahead and start, and if she wants to jump in, she sure can.
Okay. Go, Tracy.
Okay. Let's see. Wow, they really started early. Okay, here we go. I was under the belief that only an unlawful detainer assistant could assist with filling out UD complaints, a registered unlawful detainer assistant.
That is not true.
LD.
Unlawful detainer documents are legal forms that a legal document assistant can prepare. The difference is I can't give any advice, where an unlawful detainer assistant, someone who's registered and bonded as an unlawful detainer assistant, can give advice. What that looks like, I'm not real sure, but.
Very good. What was the document that you suggested the landlord fill out to ensure all occupants can be removed?
We'll be filling that one out next. We call it a PJ for short, but it's a prejudgment claim of right to possession. Judicial Council Form CP 10.5.
Great. Debbie, can you put your name down as a FBN on the summons? I noticed you put your name as DBA. You can't just list your company name?
Well, my registration and bond is under my individual name, not my company name.
Okay. Some counties, LA, have an extension for response during the moratorium. Do we know if this will apply when the moratorium is lifted?
What I know about the current state of unlawful detainers is in the amendments to the California Rules of Court that were adopted by the Judicial Council on April 6th of this year. And they say that a court may not issue a summons on a complaint for unlawful detainer unless the court finds in its discretion and on the record that the action is necessary to protect public health and safety. It also says that the sunset of this rule will remain in effect until 90 days after the governor declares that the state of emergency related to the COVID-19 pandemic is lifted, or until amended or repealed by the Judicial Council. So I had three cases that were pending when the lockdown happened in March. In three of those, I guess I had 4 cases. In 3 of those cases, the defendants had been served and they had filed answers. And so we were not able to go to trial. But under this amendment, the time for trial, once the courts even reopened and started operations again, because for a while they weren't, it says if a defendant has appeared in the action, the court may not set a trial date earlier than 60 days after a request for trial is made, unless the court finds that an earlier trial date is necessary to protect public health and safety. So that, again, that was for cases that were started prior to the lockdown in March. We talked about how an unlawful detainer action is the fastest moving case in the civil courts. That the law says when the defendants only get 5 days after they're served to file their written answer with the court. And then once a request for trial is made, the court has to notice that trial and hold that trial within 20 days of us filing that request. This has changed all of that dramatically. I have the 4th case that has been pending since early March. The defendant was served, she never filed an answer, and I cannot get a default entered because the amendments to the rules of court say a court may not enter a default or a default judgment for restitution in an unlawful detainer action for failure of defendant to appear unless the court finds both of the following. The action is necessary to protect public health and safety, and the defendant has not appeared in the action within the time provided by the law, including by any applicable executive order. So there is still a moratorium. There's going to be a moratorium for some time, I believe. But it is possible by sometime this fall or later in the year. And maybe it won't even happen till next year. When they open the gates, there's going to be a flood, I think, of evictions. I'm sad to say.
Okay. Where on the summons do you input your LDA information?
Well, wherever I can fit it in on any of the judicial council forms, it's wherever I can fit them in. So I think I just threw this one in here this time. Go back to summons. So I try to put it down here. In this case, I put it between where the address of the court is and the case number. I squeeze it in there.
Very good. If the
Because there's not room
oh, go ahead.
up at the top on this form very well. I guess I could put it right here. It could be put right there too. Okay, go ahead. Next question.
Yeah. If the notice asks for late fees in the 3-day notice, it can get kicked out.
Yes.
So for late fees or any other fees which the landlord may be entitled to, you must use a covenant to perform, which is served at the same time as the 3-day notice is served.
Correct.
Okay.
That is all correct. A 3-day notice to pay rent or quit is strictly limited to asking for the past rent. Hi, doggy. If it's 1 penny over, it could make the notice fatally defective. So it's got to be accurate, and it can only be rent. Late fees are not rent. Water charges or garbage charges or any other part of the rental agreement that asks for additional fees for things like utilities or something cannot be included in a 3-day notice to pay rent or quit. They would be, as this person stated, a 3-day notice to perform covenants or quit. So including late fees in a 3-day notice to pay rent or quit would make the notice fatally defective.
Sorry. On complaint, isn't plaintiff usually owner as well as property manager?
No, no. Most of the evictions I do, the plaintiff is the owner. This particular rental agreement that I grabbed real quick to try to put stuff together for today, it just happened to be a property manager. So no, you're either going to have the owner or you're going to have a property manager. And the property manager does have to be the one who entered into the rental agreement with the tenant, collects the rent, and then serve the notice. If the rental agreement is in the name of the owner and the owner's been collecting the rent, then the owner's going to have to be the plaintiff.
Well, that's great because you just answered the next question as well. So that was a 2 for 1. A landlord can serve unlawful detainer even if they are party to the actions?
No. A landlord can serve their own eviction notices. A landlord may not serve the summons and complaint for unlawful detainer because they are a party to the action. So a landlord could have someone who's 18 years of age or older and not a party to the action serve the summons and complaint. However, if they are having a prejudgment claim of right to possession served for unnamed adults or occupants, because see, that's an optional document. That's a document your client needs to decide whether they want to have served or not. You don't decide that for them. They decide that. But I have a little sheet that explains how the prejudgment claim of right to possession works and how it covers those unnamed, it explains it in plain English so they can make an educated decision. Yeah, there might be other adults living there that I don't know about. We should serve that. Or no, I live right next door. I know it's just the tenant living there. And then they can be pretty sure they don't need to have it served. But it's one extra service fee. And I tell the landlords it's really cheap insurance versus losing at the end of all this, and the sheriff can't do the lockout because there's all these unnamed occupants there, and you have to go back and start all over again. So.
For number 6 on the complaint, if including unnamed occupants, do we reference them in that section?
No. No, that would just be if one of the defendants that you named, because they were named in the eviction notice, was not a party to the written rental agreement.
If the agreement states attorney fees, then you should always select number 13. If not, and an attorney comes in for trial, the plaintiff will not be able to collect attorney fees. A landlord cannot serve his or her own unlawful detainer, but they can serve their own notice. I think that's a statement, but we'll just double check that it's correct.
And that person might have a valid point if an attorney were to substitute in to do the trial and the written agreement between the parties provided for attorney's fees. If I hadn't checked paragraph 13, that might preclude them from getting included attorney's fees in the judgment for the attorneys representing the plaintiff at the trial. So that's a very, very valid point.
Okay. There is now statewide rent control. How will this figure in? AB 1482, January 1st, 2020.
Okay, so most of the evictions I do are not subject to those rent limits. If you look at my 3-day notice, there's a paragraph, a statement made right under the name and address of the tenant, that under state law, this property is not subject to the rent limits imposed by section 1947.12, the civil code, yada, yada, yada. So if you're dealing with rent control on the evictions that you're having to do, then you're probably going to have to fill out something here under 14. And again, I have no experience with that. So if anyone else does that can give us some more insight on that, I would appreciate it.
Okay. How did you create your name stamp?
How did I create it?
Yeah.
I type it. Like the program I use, I don't know if this person uses Essential Forms, but I create a box just by drawing like that, see? And then because I had already typed this on the first form we did, I just copied and pasted. Just like that.
That's super simple. That's great.
Yeah. So I have to do it once at the beginning of the day, and then it's already in my clipboard, and I just paste it into every judicial council form as I'm doing it. Draw my little box and paste it in.
If there is both verbal and written contract, will we check both on 6B?
I guess you would, but if there's a written contract, usually a written contract will say it can't be modified unless it's done in writing. So I've never checked both boxes, to be honest.
Okay. What happens if the tenants rent a room in the main house? How do you specifically show that on the complaint?
I think they're asking if the owner had rented a room out in their home. Can someone confirm that's what's being asked?
Diane, if you can.
Are you asking if the owner rented a room out in their own primary residence?
Yes.
Yes.
That's what she's asking.
Okay. So then you're just suing that person. You've just given that person a notice because they weren't paying their rent for their room, and you just name them. You would not serve a PJ unless they'd moved an extra person into that room with them. And when the sheriff came to do the lockout, they would just be removing that tenant from that room. Hope that answered that.
Is the 5 days in relation to personal service? Could you go over the times for subservice or posting the docs after a judge's order?
Yes. And this is something there'd been a recent change in back in last September. Because we used to be able to count weekends. We couldn't count holidays. But now, as I recollect, and see, I haven't even been doing these for a few months now, so it's like you lose some of this stuff. But It's 5 days, not counting the day it's served, and you can't count weekends or holidays. So looking at a calendar, again, you can't count weekends, you can't count holidays. So if the summons and complaint got served on a Thursday, then the first of the 5 days would be the next day, Friday. But then you couldn't count Saturday and Sunday because they're weekends. So you would jump to Monday as your second day. And then Tuesday, Wednesday, Thursday would be the 5th day. And then on Friday, you could take their default if no answer had been filed. In the case of substituted service, you have to add an additional 10 days. And the same is true for if the summons and complaint are served under a posting order. If the sheriff or process server is unable to get anyone to answer the door, the tenants are evading service, then after due diligence, which is at least 3 attempts on 3 separate days at 3 different times of the day, a declaration of due diligence is prepared by the sheriff or the process server, and you apply to the court for an order to serve the defendants with the summons and complaint by posting and certified mailing. In our county, we have some local forms that are provided, and I gotta believe a lot of counties must have those under their local forms. So look in the local forms for the county you're trying to file in. If you can't find one, go to Shasta County and use their form and just change the name of the court. That's what I would do. But it's 15 days from the date it's either subserved or posted and mailed. Of course, not counting the dates that it was posted and mailed or subserved. If it's subserved also, substituted service, the server has to also mail a copy. So they hand a copy to whoever answers the door for the tenant who's not there, and they mail a copy to that tenant who wasn't there. And service isn't deemed complete until both those acts are done. So you want both those acts to be done on the same day if possible.
There is a request that you could briefly go over stay of eviction at the end of our program on the tenant side. So maybe we can keep that in mind depending on how much time we have at the end.
Okay, yes.
Okay, here's a follow-up question. The deadline pertains to setting trial, but not to defendant responding. For example, defendant still has only 5 days to respond.
Are we talking about the rules under the pandemic?
Diane Gunn, is that rules under the pandemic? I'm gonna let her, oh, the rent control.
Okay, ask the question again.
So regarding rent control, here we go. The deadline pertains to setting trial, but not to the defendant responding. The defendant still has only 5 days to respond.
Under a rent control or
In a rent control situation.
Oh, okay. I don't know.
Okay. And I know we covered this a little bit earlier, but if you can just remind us all again, the difference between an LDA and an unlawful detainer assistant. I believe you said the unlawful detainer assistant could give advice
Right.
on the forms.
If you read
whereas
the
an
code
LDA,
section on unlawful detainer, and even if you look at paragraph 19 on page 3 of the complaint, an unlawful detainer assistant did, for compensation, give advice or assistance with this form. So as a legal document assistant, I can give assistance filling out the form. I can fill out the form for the plaintiff, but I'm not supposed to give advice for pay. See in parentheses, if plaintiff has received any help or advice for pay from an unlawful detainer assistant state. So my understanding of the difference between unlawful detainer assistant and a legal document assistant is that if you're registered and bonded as an unlawful detainer assistant, you can give advice. Now it doesn't say legal advice, I don't even think it says legal advice in the code section for unlawful detainer assistance, but you'd have to read that to confirm. So that's the only difference I know.
Okay. Someone came in just a few minutes late and wants to know if there are 2 tenants plus possible additional, how would you mark the defendants in summons and complaint?
Well, in my complaint, I'd have Tammy agent and, no, sorry, talking about the tenant, huh? Joe tenant and Jane tenant. And then the unnamed adult occupants or unknown adult occupants are those 1 to 10. And the same on your summons.
Perfect.
And on the summons, you have to list your parties all on separate lines. Our court's a real stickler about that. So on a summons, I'd want to make sure see, they only give me 2 lines there. So I draw a line in if I have 2 tenants. And I'd have Joe tenant. Jane tenant. And Joe's 1 to 10 inclusive, just like that.
Great. I have no idea what Julia is asking here. It says OP1 number 1 and P2 number 7. Can we name defendant and does 1 through 10?
I understand the question.
And you know what? We can cover this
Come on
one.
and ask us.
Maybe she can add in some additional information. I have several new messages, so we're gonna new chats. So we're gonna move on, and if Julia can flesh that out a little bit for us.
Okay.
Can you have 2 plaintiffs mentioned in the unlawful detainer action? If they're both on the rental agreement, does it complicate things when 2 are listed?
No, other than, the forms are made up for just 1 person to sign as the plaintiff, but I just have them squeeze signatures on, or I add an extra line in, by drawing the box. In the case where you got like a mom and pop rental, and both husband and wife are on the rental agreement, if we don't name both of those parties as a plaintiff, and this goes to trial, only the person named as plaintiff can get up and talk. I mean, technically they'd be able to call their spouse as a witness, but yeah, I always name both parties as a plaintiff unless they have a reason they don't want it done that way, so they both can go to trial and speak.
Can a property manager that is not a corporation file an unlawful detainer on property held in LLP, corporation, etc.?
Yeah, as long as the property management is just an individual and not a legal entity, then they can represent themselves in a court of law, and it doesn't matter that the owner is actually a legal entity.
Would you recommend sheriff or process server serve the summons and complaint, and then they file POS with court?
Proof of service. In my experience, I've always preferred a private process server because in our county, our civil division of our sheriffs don't work weekends and they don't work nights. And my private process server always did. And unlawful detainer actions are very time sensitive and you want them served ASAP. So shortly after I opened my business as a legal document assistant, my spouse became a registered process server. And he did an awesome job for like 2 decades, and we just retired him back in March. So I'm going to miss him when I start doing evictions again because he was very good at his job. And most process servers are a little more diligent than I think the civil division of the sheriff's office has maybe the opportunity to do. I don't know. But they definitely work more hours than the civil division of the sheriff here in our county.
How would you sue if there is a property manager who a person pays rent to on behalf of the owner, but the actual rental agreement is signed by the owner of the property and not the property management company?
Then the owner would have to be the plaintiff, I believe, unless they had a separate management contract that specifically gave the property manager the authority to sue as plaintiff in an unlawful detainer action. I have used that in the past.
Do properties held in corporations or LLC have to use attorneys?
Yes. As individuals, we have a constitutional right to represent ourselves in a court of law. A legal entity is not an individual person, and they must be represented by a licensed attorney. The president or a member of an LLC can't represent that entity because they are not a licensed attorney. That is the law.
Okay. Let's see. What date goes on 17F?
Are we talking the complaint, I presume? 17F is the day that holdover damages start. So in this case, we had a 3-day notice to pay rent or quit that asked for rent through the end of July, July 31st. So the first date that we want to capture the rent starts on August 1st. In the case of a 30-day or a 60-day notice, you would not check the box for past due rent because your eviction notice was not asking for rent. It was just asking to terminate the month-to-month tenancy. So in that case, damages, holdover damages would commence the first day after the period in the eviction notice expired. So with a 30-day notice, that would be on the 31st day after it was served. Or a 60-day, it'd be the 61st day.
Okay, there's still some confusion on rent control. The governor's order seems to make it statewide, no longer by county. This is new, so how would we go about addressing that?
I may not be familiar with what you're talking about.
Okay.
If you're saying this is new and something that's just been ordered since the pandemic, I'm aware there was some laws changed back last fall about rent control, and that's what this paragraph in the very beginning of my 3-day notice addresses. But if there's something that's happened since then, I'm not familiar with it.
Okay.
And again, that really has nothing to do with an eviction other than how you fill the form out. That's something the landlord's going to have to get legal advice on as to, you know, can they increase the rent? Can they? That has nothing to do with what I'm preparing.
Okay. Is there a set fee for an LDA to fill out these forms?
No.
Okay.
And I think our fees for the work that we do vary from county to county in this state. I think those that work in Southern California are able to charge more because wages and such are higher in the southern part of the state compared to the northern part of the state. So I have a flat fee I have that I charge. Over the years, it's increased. Every couple, 3 years, I review my flat fees and kind of increase things because overhead keeps going up. Paper, stamps, toner.
If there are 4 tenants listed on the agreement, do you list them all?
If they're all still occupying the premises, yes.
What if 2 minors were listed but are now of age and did not sign the agreement?
Then I definitely encourage the plaintiff to serve a prejudgment claim of right to possession to cover those unnamed adult occupants. I would not include them as defendants, no.
On page 1 on complaint and on page 2, number 7, do we add Joe Tenant and Joe Tenant and does 1 through 10? That's the question.
Okay. So what paragraph?
So on page 2, number 7.
Page 2, number 7. No,
Okay.
I would just put the name of each person that was served with the 3-day notice. Each named person, not the does 1 through 10. No.
Good. There are some links here for the attendees on Business and Professions Code, and you guys can click on those on your own. Another question, the PJ has to be served by a process server or sheriff, according to the code, correct?
That's correct. It was something I was going to mention when we got to that form, but yeah, if you read the code section that is cited on the prejudgment claim of right to possession form, it specifically states that if you are having a PJ served with your summons and complaint for unlawful detainer, it must be served by a sheriff or registered process server. So in that case, you could not just have your friend who's over the age of 18 years old serve the summons and complaint for you, because you're serving this PJ for unnamed adults.
If a 60-day notice was served, not due to late rent, should the summons should be served on the 61st day?
When that 60-day notice has expired, then on the 61st day would be the first day you could go file with the court your summons and complaint for unlawful detainer. If you filed it 1 day too early, you could lose at the end of all that because you filed it too early. Whether you got it served that same day would be, depend. But you definitely could serve it on or file it on the 61st day.
Final question. What fee do you charge for ULD, and does it include filing fee? I think it's supposed to just be UD.
Okay.
It's a typo. And does
No,
it
my
include...
flat fee specifically just includes my preparing the forms. It does cover photocopies and postage, and my office filing the documents with the court. It does not cover any of the court costs, the filing fee, the process server's fee, the sheriff fees, none of that.
All right. We have one more question.
Okay. I'm going to get the next form opened up.
17F, what date do we enter?
Oh, 17F. Oh, well, we already talked about
We did that.
Yeah, that's when your holdover damages start. So in this case, it was August 1st because our 3-day notice asked for rent through July 31st. In the case of a 30-day or a 60-day notice, the date you would type in there would be the first date after your 30-day or 60-day had expired. Hope that answers.
And we're going to go ahead and start with the next form,
Okay.
Debbie, if that's all right with you.
Yeah.
While you're pulling that up, Donna, she did cover the reasonable fee, and it was simply that each county, each kind of area in California can charge different amounts just based on, Southern California may charge more because they have a higher income and that kind of thing. So you would just need to decide what to charge on your own and see if your area would pay that, people in your area.
And for me, what I have an hourly rate that I consider my services are worth. And when I came up with my flat fees, I tried to take into account about how long the average case would take me, including preparing the documents, making the copies, filing with the court, going back over when the default could be filed or the request to set a trial date. I tried to take in the amount of actual time and calculate it from there. And do some cases, by me charging a flat fee, do some cases I make more on and some I make less? Yeah. You probably all know some clients are more high maintenance than others. And some cases may become more high maintenance, but on the average, I think with my flat fee system, it works out pretty well for me.
Okay, we will stop taking questions right now. Don't worry, I know exactly where we're going to pick up, And Debbie, go ahead and start.
We're going to look at the prejudgment claim of right to possession form. That is Judicial Council Form CP 10.5. Now, this is not a form for the plaintiff. So this does not have the plaintiff's information up here. If you read the form, this is for the claimant. So the claimant, this unnamed adult who's occupying the premises, who just found out there's this eviction action going on because they found a summons and complaint with this prejudgment claim of right to possession pasted on the front door when they came home from work the other day. This is where they would put their name, address, and phone number. So in this case, all that gets filled out with this document to go get served on the defendants is the name of the court, your court caption, your case number, the address of the property, and in here I insert the date that we filed the summons and complaint with the court. So that would have been August something. And then I also insert what the defendant will have to pay to go file this with the court, which is $225. That's all you fill out on a PJ. My husband used to serve unlawful detainer documents for an attorney here in town, and she always had it all filled out with her information up here at the top. So, you know, sometimes people just don't stop and read the forms, and it's just like in probate or guardianships or conservatorships. It's so important to read the form and be aware of what you're filling out. And watch, because they change those forms every now and then too. So again, as was brought up earlier, if you are having a PJ served with your summons and complaint, it must be served by a sheriff or registered process server. Any more questions on this form? Nope. So your defendant's been served and their time to file an answer is up. And here in my county, I have an email address for the unlawful detainer clerk over at the court, so I can just shoot her an email. Because unlawful detainer actions are kept private for, I think it's the first 60 or 90 days after they're filed. So I can't even go and look it up on the court program I have, where I could usually look up, like in a family law case, if somebody filed a response to a petition for divorce. But I can email my court clerk and she'll let me know whether an answer's been filed or not. If not, then I'm going to get filed with the court as soon as the time is up and I'm able to do so, the request for entry of default. So let's pull up Judicial Council Form CIV 100, request for entry of default. And again, you got to put your information up here. And you know, I don't know who designs these forms, but they sure don't leave us a lot of room. You have to get real creative on where to get your information in there. So in this form, and of course you got your case number over here. Always remember to get your case number when you go to file. Now, the summons and complaint, you didn't have a case number yet. But once that comes back from the court, you want to be sure all the rest of the forms that you submit to the court have your case number. So to enter a default, we're going to check request for entry of default, because as most of you hopefully are familiar enough with this form to know it can be used for several different things. But in this case, it's going to be for entry of default. 1A is the date that the complaint was filed with the court. By who? Our plaintiff, Tammy agent. We want to enter the default of Joe because he didn't go file an answer with the court. Nothing else gets filled out on that page except here, because we are just asking for a default. We're not asking for any kind of judgment. And let me go back and state that when a prejudgment claim of right to possession is served, you cannot get a clerk's default judgment for possession until the 11th day after the summons and complaint and the PJ were served. And again, that's going to be in the code sections that talk about service of the PJ. So become familiar with that. Your tenant only has 5 days to go file their written response, but the unnamed occupants have 10. So on the 11th day, I can take my request for the clerk's judgment, which we'll do next. But this is just the 6th day after service, and we want to get the default entered against Joe, so he can't go file an answer late. So you put your date in. And Tammy signs it. A legal document assistant or unlawful detainer assistant. I am a legal document assistant, so I did for compensation. And here's where I find it confusing in the form. Give advice or assistance with this form. So that question that goes back, what's the difference between a legal document assistant and an unlawful detainer assistant? All I can do is encourage you to read the 2 code sections and determine for yourself what the difference is. So then I have to enter my information here because I am a registered and bonded legal document assistant. I hope you all are following along and typing this, because doing is the best way to learn. I'm registered in Shasta County. December 12th. I think that's right. Maybe it's 21. Okay. So this is something I learned in an unlawful detainer class I took from Joe Beal, I think is her name. I had always filled out 5 and just said is not, but and is not. But she pointed out that if I were to read this code section, I don't think I even have to fill this out. But I'm in such a habit of filling it out, I still do it, even after taking Joe's class. Okay, the request for entry of default, the copy has to be mailed to the defendant. So I put in the date I do that. And the address I mailed it to, and the name of the party. We're totally going to skip over 7 because we're not asking for any kind of money judgment yet. This is required only if a money judgment is being requested. We're not. We're just requesting entry of a default. I do fill this out even though it says required for a judgment, because you can't take a default of a service member under that Civil Relief Act. So and that's our request for entry of default. So Joe got served. He didn't file his answer within 5 days. So on the 6th day, I went and filed this with the court. Any questions on that form?
We actually have a couple of questions here.
Okay.
So before we go too far forward, if we could answer them, and then that might be a good time to take a break.
Ooh, potty break, yeah.
Yeah. All right. So the first one would be, what document do we fill out for late fees and past due utilities, etc.?
Those would be requested under a 3-day notice to perform covenants or quit.
This is just some advice for mom and pop rentals. Ivette always sees if they qualify for a court fee waiver, because you'd be amazed at how many landlords will qualify. So that's something.
That's a good point.
Yeah.
I didn't think that would be possible, but I've done several evictions over the years where the plaintiffs were, you know, property poor, and without the tenant paying rent, their monthly income was sharply reduced. So yeah, you always want to think about that if you can, to help the plaintiff.
The property has to be in the same county that you're registered as an LDA, correct?
No,
I didn't think so.
I'm registered as a legal document assistant in Shasta County, and I've done evictions in Siskiyou County and Tehama County.
And then there was a follow-up question that I'm going to answer, which is anyone registered in 2 or more counties? Does
Not
your
necessary.
LDA, what's that?
It's not necessary.
Correct.
Unless
So,
you have a brick and mortar in both those counties.
right. So I bet the law changed. You do not have to have multiple LDA registrations unless, like Debbie said, you have brick and mortar offices in different counties, then you would need one for each. But otherwise, you are allowed to work in all 58 counties with your singular LDA registration. If 2 listed tenants did not answer, can you put them both on the request for entry of default, or do you have to do a request of default for each tenant?
No, you can name them both. If they were both served at the same time.
Okay. Random question on this, PJ. Can LDA file her own eviction, or will this be thrown out by the courts?
So I'm an LDA and I'm also a landlord. Is that the question? Yeah, you could prepare and file your own paperwork.
That's what it sounded like.
Uh-huh.
And then would you file 2 entry of default if PJ was served, 1 for defendant 6 days after no response and 1 for unnamed tenants 11 days after?
You don't file a request for entry of default on the unnamed tenants. So the next form we're going to do is a request for the clerk's judgment, and that is the document that would be filed on the 11th day after service.
Okay. And then there is a question to me about copying the chat info. Maria, I will look into that and see if I can unblock it. Okay. And that takes us to the next form. Oh, takes us to our break. Does that sound like a good idea?
That sounds like a great idea.
Okay, so we're gonna have a 15-minute break, everyone, and we'll see you back
And
in a
then
few
we'll be
minutes.
pulling up that same form, request for entry of default, Civ 100, but we're going to fill it out different. So if you want to be ready for that.
Perfect.
All right.
There we go. And we're back.
Okay. So I was reading some of the chats that were going on between the members while we were off there. These forms might seem intimidating to you because you've never done them before. But after you do a few of them, they are not that hard and they do not take that long. When a landlord comes in and hires me, I sit down here with them in the room and I prepare all the documents they might need to sign, and it might take me 15 minutes, 20 minutes tops. That's while I'm talking to them, you know. So once you become familiar with the forms, it's like anything else you do, the more you do it, the faster you get at it. So don't be intimidated by the forms. They're just simple judicial council forms. You just got to know the right boxes to check and the information to put in there, which is what I'm hoping to share with you today. So our next step, we filed the request for entry of default against Joe, who did not file his answer, and it's now the 11th day after service. We can now request a clerk's default judgment for possession of the property.
Debbie, excuse me, your documents aren't up on the screen for
Why?
sharing.
Okay. Share. Sorry. I had done that once and then it said it paused it for whatever reason. Can
There you
everyone
go.
see it now?
Yeah, it's good.
Okay. So again, always put your info in up here. I'm not going to do that now because I want to be sure we get through everything here. Okay, this request will be for clerk's judgment. We're not requesting entry of default again. That's already been done. The default's been entered against Joe. That blocks him from coming in and filing an answer late. Now we're going to fill this particular form out with regard to requesting a clerk's default judgment. So again, the date your complaint was filed. We're not going to check that box because we already have a default entered against Joe. We're not going to check D because that would be where we'd be asking for the money judgment that the judge has to sign. This is a clerk's judgment, E, for restitution of the premises only and issuance of a writ of execution on the judgment. If the PJ was served for unnamed adult occupants, we would check this box to include in the judgment all tenants, subtenants, named claimants, and other occupants of the premises. And then for a default previously entered on, so we entered Joe's default, what, 5 days ago? So we would have that date in here. Again, we're not entering any amounts here because we're not going after our money judgment yet, but we do have to check 3 because we are either a legal document assistant or unlawful detainer assistant. And our date. And again, our information about ourselves. Either we're a legal document assistant or an unlawful detainer assistant, and fill out that. Again, I do this, even though it may not be necessary. And we have to mail a copy of this to Joe. Again, we skip over 7 because this is only if we are requesting a money judgment, which is not what we're doing right now. We're requesting a clerk's default judgment for possession only. So we can get that writ of possession issued by the court clerk, get it delivered to the sheriff, and the sheriff can serve that and schedule a lockout date. And that's all you do on that form. Then we want to prepare our clerk's judgment for default because that needs to go to the court at the same time. This form I already had prepared when the landlord first came in and hired me. He's or she has signed it, and all I've got to do is prepare my judgment, my clerk's default judgment for possession, and my writ of possession, and take those 3 forms to the court with my $40 to have the writ of possession issued. And that's all that would go to the court at this time. So let's look at the judgment form, which is UD 110. Again, you're going to put your info up here. Judgment. This is just by the clerk only. Does not go to a judge for signing. By default. Possession of the property only. Those are the 3 boxes you would check for a clerk's default judgment for possession only. Number 1 is by default, and D, clerk's judgment for possession only of the premises described on page 2. Everything else you skip over here. Nothing else is checked on page 1 for a clerk's default judgment. The judgment is entered as follows by the clerk. Our plaintiff, and number 4, plaintiff is entitled to possession of the premises located at, and this has got to be your rental address that the tenant's living in, that we want them locked out of. And if you had a PJ served for unnamed adult occupants, you would check 5, that the judgment applies to all occupants of the premises. We do not put any amount or terms of the judgment because, again, that is a judgment that has to be signed by the judge. We don't want to take the time for this to have to go to the judge to get the money judgment at this time. We can do that later, after the lockout. That is all that is done here. You check clerk and print your document off and prepare next your writ of possession. So that is EJ 130. It's also a writ of execution, depending on what box you check. Again, put your who prepared the information. Tammy is the original judgment creditor. This is not on a judgment that's been assigned. And here's where you have to choose. We are not doing an execution on a money judgment. We are doing a writ of possession of real property. And this was on a limited civil case. To the sheriff or marshal of the county where you're doing your eviction, that the property is located at. Tammy is the original judgment creditor, not an assignee. And Joe, our tenant, and the address of the property. Judgment was entered on. So that would be the date that I knew I was going to take this over and stand at the counter and have the clerk issue it. Now, I don't know in some counties if you can take it to the counter and stand there and have them issue your file your clerk's default judgment and have your writ of possession issued. We can here in Shasta County, or at least we could before the pandemic. I don't know what life will be like afterwards, but I was always able to enter the date I knew I was going to be taking this over. If you don't know that date, leave it for the clerk to fill in. A notice of sale under this writ has not been requested. And 9, see the next page for information on real or personal property to be delivered under a writ of possession. Here, our court wants us to put zeros in all these places, and I can't even see this part of my screen, so I hope the zeros are going in there. Yep. So amounts couldn't be entered in after the clerk issued it. They want that clear that those are zeros. If there's an additional judgment debtor, like over here, say we had 2 named tenants, say we had Joe and Jane tenant, you would check additional judgment debtors on the next page. And here's where you'd write in Jane's name and the address of the rental property. The address. You skip over everything else till number 24, writ of possession. Judgment was entered for the following: possession of real property. And again, we have to write in the date our complaint was filed. And here you have to indicate whether the PJ was served or not. In this case, it was served. If it was not served in compliance with CCP 41546, you would check 2. And down here, some courts have specific dates that they will hear objections to the enforcement of the judgment with regard to PJs. So like in Colusa County, when I do unlawful detainer forms for Nancy in Colusa County, their court has something specifically I have to write in there, and I have a cheat sheet I refer to. So you have to find out individually in the counties you're filing in, what are their local rules and practices? And that's something you may only learn by doing. The best things I ever learned were by making mistakes. So don't be afraid of making mistakes. Then you have to describe the property where the writ of possession is to be enforced. The property is described below and the address of the rental property. And that is all we have to fill out. There is a third page here, but there's nothing on it that we have to fill out. So are there any questions on those three forms? The request for entry of the clerk's default judgment, the clerk's default judgment itself, and the writ of possession.
So I'll go ahead and take the chat questions. I'm going to start with, somebody asked, oh, could you please provide a chronological timeline for document submission starting with the 3-day notice? Maybe we should hold that till the end.
I want to point out that part of the materials that were sent to you, there is an unlawful detainer procedure list.
Okay, so that should take care of that.
It does give you a timeline from the filing of the complaint as step 1 through, wow, did it not all print?
I think I had it. It came with me.
Anyway, there is somewhat of a procedure checklist there, and I could probably enhance on that some, but more or less that tells you when you file the next document. Like we've been talking about step 3, if a PJ was served on the 11th day after service, you file the following, and then it's got the list of the documents that you submit to the court on the 11th day that we've just finished discussing here, the clerk's default judgment. Oh, we also didn't get the request for dismissal. So if you name does 1 through 10 in an unlawful detainer action, you also have to dismiss those does before you can get a judgment or a trial date. So you would need CV or CIV 110, request for dismissal. And you would dismiss without prejudice does 1 to 10 inclusive. And you would need to know if the court waived court fees and costs for any party in this action. Here in Shasta County, if a defendant has filed an answer to an unlawful detainer complaint, I can almost 99% of the time presume the defendant got a fee waiver. So the court did waive fees and costs for a party in this case. Put your date, the name of your plaintiff, who's a party without an attorney, and that's where Tammy, agent, would sign. On page 2, the court waived fees and costs in this action for Joe tenant, and the person in item 1 is not recovering anything of value by this action. In fact, we're going to kick the person named in item 1 out of the property. Date it, put Tammy's name there, who's a party making the declaration, and Tammy would sign on page 2. So always remember that if you served a PJ and you named does, you must dismiss those does before the court will grant you a judgment of any kind, or before the court will set a trial date. If the defendant filed an answer and we've filed a request for a trial date, you better be sure you file your request for dismissal of does with that request for a trial date, or you won't get your trial date set.
Okay, so the next one is Y2 request to enter default.
We're only doing one request to enter default. The second form, same type of form, right? It's still CIV 100, but we're checking different boxes. So we're using it to request a clerk's judgment, not a default.
Okay, what if the defendant is in the military?
That's a whole nother can of worms that I'm not going to get into right now. You can't take a default against someone in the active military.
Right. I see you use the plaintiff signing the POS. Is this correct? She can serve her own documents?
She can serve her own eviction notice. She may not serve her summons and complaint for unlawful detainer.
Okay, somebody said, can you repeat this form, please? Debbie, slow down a little, please. I'm not sure what form she's referring to, so.
Okay.
Someone says, our clerk won't allow a request to enter default without a request for dismissal of all does being entered, those being entered first. I think you just covered that, right? About
Yeah, I think so.
right.
Hope so. And I'm sorry if I'm going too fast. I'm looking at the clock going, I want to make sure we get through all the forms. So I'll try to slow down.
You filed the clerk's judgment by clerk. Okay. Do you file the clerk's judgment by clerk, and writ of execution together?
Yes,
That's 3 documents.
on the 11th day. Okay, and this is in the case where we've had a PJ served. On the 11th day, I would take over to the court the request for entry of clerk's judgment, the clerk's default judgment for possession only, and the writ of possession with my $40 fee to have that writ of possession issued, and the dismissal of those.
Okay.
The 4 documents you're going to take over on that 11th day.
Okay, someone wants to know if these are public records. I assume that's what they mean.
They are public records, but not until, I can't remember if it's 60 or 90 days after they're first filed. They aren't initially public records. There's something in the code sections about them not being public records until a certain time period after. I don't know why that is in the law. Maybe to protect the tenant from not being able to go out and find a new place to rent. I don't know. But they are not public records initially. They become public records later, after the eviction's over.
Can you please repeat the process for request for dismissal for the does?
Go back over the form again.
I would think that.
Okay. So the request for dismissal, paragraph 1, we want this action to be dismissed without prejudice. So we check A2 and we check 6, other, and type in does 1 to 10 inclusive. We have to check the box here on whether the court waived court fees and costs for any party in this case. So you would want to check with your court clerk to see if a fee waiver was filed, unless you could assume there wasn't one. I mean, there was one filed. If tenants aren't paying their rent, they probably don't have money for the filing fees either, is the presumption that I usually make here in Shasta County anyway. And then on page 2, you have to fill out the declaration concerning waived court fees and the court waived fees and costs in this action for the tenant who is not recovering anything of value by this action. Dated and signed by the plaintiff on page 2 there.
So Yvette gave information that Riverside Superior Court under UDT actions has a step-by-step for both landlords and tenants case-by-case scenarios with sublinks plus UD landlord-tenant flow chart. That's how she learned. So
very good. That's good to know. Write that down. What county was that again?
The Riverside Superior Court under UD action has step-by-step for both landlords and tenants case-by-case scenarios with sublinks plus landlord-tenant flow charts. This is how she learned the UD action. So I guess anybody could go to the Riverside Superior Court
website and get that flow chart and that information. That would be very beneficial.
That sounds really
Set yourself up a form book, either in your computer or even in a binder, and have it to look at when you first start doing these on your own. That was my hope, that people could follow along and fill these forms out with me this morning so they could create that form book for themselves where they could go back and refer to it. The class I taught a few weeks ago, when was that, Tracy?
I don't think Tracy's here. I think
okay. Anyway, I taught a class on evictions a few weeks ago, but it was just for an hour. So the class materials provided there included all these sample forms already filled out. So if that isn't accessible to you through CalDA, email me. I can email you that package of documents that were used for that class. that were already all filled out, and you could add them to your form book.
Somebody asked what software you use. I think you said you use Essential Forms.
It's CEB Essential Forms. See right up here in the corner?
Okay.
They update their forms twice a year, just like the Judicial Council. I find them very reasonable in the cost.
Yeah.
Seems like it's about 400 and something a year, which for something that I use on a daily basis, that's a good price.
And Diane Guzman says Monterey County 60 days. I'm not sure what she meant by that. Maybe she'll resend it.
I think probably she's talking about how long the cases are kept private. And I think it is
okay.
60 days, right? I just didn't want to misstate, so. But I think it is 60 days that the law, there's something in the code section that makes them, the courts keep it not public record for the first 60 days after it's filed. Does
your CEB software let you e-file to all counties or just certain counties?
That does have e-filing. I have never used it. So I do not know the answer to that. But let me show you. There's the 800 number for customer service for CEB. You could call and ask. Ask them any questions you needed to before you decided to invest in the program.
That's cool.
Everybody get that?
Yep.
Okay.
For Maria, what is the role in your point of view? ROLE. I'm not sure what she's talking about. Do you know ROLE?
What is the role of what or of who?
It just says, what is the role, ROLE, in your point of view? And then it just says yes, so I'm not sure.
So my role for a landlord who comes in and hires me, from my opinion, is to not only prepare the forms, but process them through the court system, keep the case moving. I have, a calendaring system where once a tenant is served, I calendar when the next step can be done. So I immediately do that as soon as that date comes up, because unlawful detainers are very time sensitive. For every day there's a delay, the landlord's losing money. And I only do unlawful detainer work for landlords. I don't do answers for defendants. If someone calls here and it is a tenant and they need an answer to an unlawful detainer complaint, I will refer them to other LDAs in my town that I know. Just because I worked for attorneys for so many years, I don't want the risk of any conflicts of interest. And I do not know preparing forms for the tenants like I know preparing forms for the landlords. I worked for an attorney for 10 years who did a tremendous amount of evictions. They used to call him the landlord king here in Shasta County. And that is where I learned to do evictions, doing several a day at his office. And that's all he represented was landlords, plaintiffs in eviction cases. So that is where my knowledge lies, not in preparing forms for tenants. But there's going to be a need for that too. So again, you might want to study the answer form in an unlawful detainer action. It is a judicial council form. Some of the defenses that might come up for non-payment of rent would be habitability issues. And there are code sections you can read to familiarize yourself with what's considered uninhabitable and help tenants in that way too, because there's going to be a huge need for that. Tenants are going to want to try to stall these cases out by filing an answer, and they're going to need somebody to help them fill that answer form out. We won't be covering that form here today, but I would encourage you to work at educating yourself.
Tracy and I did talk at the beginning this morning about possibly doing a class on the tenant side.
That would be wonderful if someone has experience and could do that. That would be great.
We're going to look into that, so that would help. Can you expunge an eviction of a record at all? So I assume if somebody got an eviction notice, they want to know if it can be expunged.
I have never heard of that, no.
No, okay.
I
You
think
met-
once it gets filed as a summons and complaint with the court, it's there forever.
You mentioned the request for dismissal had to be filed along with something else in order to be valid. What was that process?
In our court here in Shasta County anyway, we have to dismiss those does, file the request for dismissal of the does before the court will grant a judgment or a trial date. So I submit the request for dismissal with the request for clerk's judgment for possession only. Or in the case where a tenant has filed an answer, I submit the request for dismissal with the request to set case for trial. So they'll set a trial date.
Okay, I'm not exactly sure what Gwendolyn meant. She said that is correct. It's to prevent any potential landlord from checking on tenants' eviction status. I'm not sure.
Right. So they can go out and find a new place to rent, you know. Hi, Gwen. I'm so glad you're with us today.
Oh. Please repeat the 4 documents that need to be filed on the 11th day of if the PJ is served.
Okay. You want the request for clerk's judgment, which is Judicial Council CIV 100. If you have named does in your summons and complaint, you need to file the request for dismissal of does 1 through 10. CIV 110 is the number of that form. You need to file the clerk's judgment for possession only, which is Judicial Council Form UD 110. And you need to submit with all those documents your writ of possession, which is EJ 130. And $40 is the fee for the clerk to issue the writ of possession.
Okay. The unlawful detainer class that you did previously is on the website. If anybody wants to, they can get on the website, the CalDO website,
and watch it. I just don't know if the materials that were sent out before the class are available there also.
We'll check with Tracy about that.
Okay.
Somebody's asking for your email. Maybe they can get that on the website.
That's on the CalDO website, or
Yeah.
you can look up Quality Document Preparation Center. I have a website that it's available on.
Right, okay. Diane asked for your contact information too, so I want to try and get through these.
Yeah.
Maybe we should stop. I'm going to stop at the question. Angela said, LDAs and UDAs have no conflict fiduciary duty for form preparation. We could assist with both, correct? I guess that would be up to the person, right?
Yeah. Oh, yeah. I could do paperwork for tenants. I just choose not to. If I was hungrier for business, I would take whatever walks through the door mostly, but I'm really busy these days, so I get to be particular.
Okay, so I'm going to stop at the 1102 question for Phyllis Howard, and we can pick up from there. So if you want to, we probably should get going on the rest of the.
Right.
Okay.
So we have our writ of possession issued by the court, and we now need to send some instructions to the sheriff and deliver that issued writ to the sheriff so they can schedule a lockout date. In the materials that you were sent, should have had this all up. Oh, I don't even have access to it from here. In the materials that you were sent, there was a document entitled Levy Instructions, and it said to the Shasta County Sheriff and it's the instructions for the sheriff to, by virtue of the accompanying writ of possession, to levy as follows: to regain possession of 1891 School Street in Anderson. This property is a residence, and the writ of possession is to be served on Joe Tenant and any and all unnamed adult occupants. We add that verbiage, and any and all unnamed adult occupants, because we did serve the PJ for unnamed adults. And you are to return said premises to the plaintiff or her authorized agent. And then I have to provide the name, address, and phone number of the plaintiff. And I include in my instructions my information, because then the gentleman at the civil division of the sheriff will call me and let me know the date and time of the lockout. And I can notify the landlord as soon as I know, and they can arrange for a locksmith or whoever they're going to need to help change locks or or rekey the premises at the time of the lockout. So our civil division used to be in our courthouse, and I had a will call there, and we could just pick up this information, and then I would mail it off with a form letter to my plaintiff informing them the date and time of the lockout, encouraging them to be there at least 15 minutes early because the sheriff's always on a really tight schedule. But our sheriff's civil division has moved across town, and it's now changed the way I'm doing things here, so that we don't get that letter sent out anymore. There's never time. I just call the plaintiff. So again, part of my flat fee includes facilitating the entire process to make it easy for the landlord. So you have to decide what your fee is going to cover and what you're going to leave for the plaintiff to do. Anything else there, Kathy? Hello?
Sorry, I was muted. Are there more forms?
Yes.
Okay, so why don't we go ahead and
Okay.
do some more
So
forms.
let's backtrack and presume that Joe Tennant filed his answer in a timely fashion. Now we want to request a trial date. So if we have named does, we have to do that request for dismissal that we just went over. It's filled out the same way, whether it's by default or we're going to have a trial date. So we aren't going to revisit that form. But you also need to submit a request for a trial date, which is UD 150, Judicial Council form. Request to set case for trial. Request by the plaintiff. Those are the two boxes you would check if you were doing this for the plaintiff. I can't imagine the defendant requesting the trial date, but they can file a counter request. And I have seen things in past history where legal aid was helping tenants out because they had enough money for funding to do that. And they would file a counter request for a jury trial. That would really delay the action a lot. But most of the time, we're just filing this for the plaintiff as a request to set the case for a trial. So you check one, this is the plaintiff's request. I represent to the court that all parties have been served with process and have appeared or had a default or dismissal entered against them. I request this case be set for a trial. Then in two, you have to put the address of the premises and read this. This says, and the county over here. So you want to be sure you also say what county this address is in. To the best of my knowledge, the right to possession of the premises is still an issue. So if you start an unlawful detainer action, serve the defendant, and then they move out, the unlawful detainer action either needs to be dismissed because possession of the property is no longer at issue, or it needs to be converted to a case just for asking for the monetary damages. And I'm not sure how you do that, convert a case. So can't answer any question there. Jury trial, I request, no, we are not requesting any type. We want a non-jury trial. So that would be just in front of a judge. From my experience, I know the estimated length of time for the trial is half an hour. That's all I put in there. Can't see that part of my form, but I hope that printed okay. Now, you always want to check when you're filling this form out, and this is something I do when the landlords initially come in to hire me to do this, because I'm preparing all these forms in advance for them to sign, if they have any prepaid vacations planned in the near future. So dates and reasons they would be unavailable. So you want to always check with your landlords on that, assuming the trial is going to occur at least within 60 days of when you're meeting with them to initially file. Unlawful detainer assistant, I am not, so I checked did not there. Although I always make sure my information is up here at the top of the form so the court knows I prepared it. So then down here, date, type Tammy's name there, and she would sign. On page 2 is just a proof of service by mail. You must mail a copy of this to all named defendants. So Joe has to receive a copy of this. But first I'm going to type in my information here, my business address. And I'm saying I served a copy of the request to set case for trial by enclosing it in an envelope with a stamp and depositing it in the U.S. mail. You indicate the date that it is mailed to Joe. And from what city and state you mailed it. And then the date and my name. And I sign it. Below here, you have to indicate the name of the named defendants that you served it on. So I served Joe Tennant by mail at his address at the rental, 1891 School Street. So we've named does. When we submit this to the court, it's with a request for dismissal of those does and the request for the trial date. Upon receiving it, the clerk has to mail notice of trial to both the plaintiff and the defendant. They have to give at least 10 days notice of the trial date, and the trial needs to occur within 20 days of us filing this request. That is all pursuant to the code sections that govern how fast unlawful detainer actions travel through our civil courts. If we went to a trial, let's look at how we would fill out our form. So it's the same judgment form as for a default. We're just going to check different boxes. So it's Judicial Council Form UD 110. And we are going to check a judgment after court trial by the court. We skip over 1 because this is not by default. This is 2, after court trial. You type in the date and time of the trial. So I don't receive notice from the court of the trial date. My landlord does, my plaintiff. So they have to be told that they need to notify me when that happens and give me the date and time of the trial. What I will do, our trials are always on Fridays. And I will set up a brief appointment with them a day or two before that to meet with them here in my office. At that time, I give them a file folder that has all their documents in it, everything we have filed with the court, from the summons and complaint through the request for the trial date. If I have a copy of the answer, I put that in the file. And then I take yellow stickies and I tab at the bottom of the documents that my plaintiff might need to refer to during the trial. I will tab the 3-day notice to pay rent or quit because they may need to refer to that quickly. I will tab the rental agreement if there is a written one. I will tab the complaint because that is their case against the defendant. And I will tab the answer from the defendant if I have a copy of that. You have to teach some of these landlords how this process all works. So you have to let them know. If you get a copy of the answer in the mail, let me know. I need a copy of that for your file here. If you don't get an answer by such and such a date, notify me, and then my office will go over and get a copy from the court so we know what the defendant is claiming and the plaintiff can be prepared for that at the time of trial. So again, these are all services I provide under my flat fee that make the process easy for my client. Appearances were made at trial by our plaintiff, Tammy. And we assume the defendant will show up too. Although some tenants will file answers just to stall for time and then they don't show up at the trial. In which case the judge will scratch this out and initial it and indicate he'll check defendant did not appear at trial. Again, to answer D here, a statement of decision was or was not requested, that is something that would appear in the answer to the complaint by the defendant. So if you don't have a copy of the answer, you don't know if it was requested or not. So it's kind of important to get that, although I confess to having made assumptions before that a statement of decision was not requested, because you don't see that very often. If legal aid gets involved in doing answers for a lot of tenants, which may happen here when the floodgates open up after this pandemic, that is one of the things you will sometimes see in an answer prepared by legal aid, because it does kind of delay the action. A statement of decision is something the court would issue, justifying why they decided the way they did in the case. On page 2 in this judgment for after the trial, this is the judgment that's going to be entered by the court. It's going to be signed by the judge. Judgment is for our plaintiff, Tammy, and against the defendant, Joe. Or the plaintiff is entitled to possession of the premises located at the address of the rental, including the county. And in this case, we did serve a PJ, so we would check 5 that the judgment applies to all occupants of the premises, including any unnamed occupants. And in this case, at the trial, the judge is going to make a determination of the money judgment also asked for in our complaint. So the amount that defendant must pay to plaintiff is our past due rent, which was what was asked for in the 3-day notice to pay rent or quit. Holdover damages. So those are calculated. If you go back and look at page 3 of your complaint, under the prayer, we asked for damages from August 1st to the date of judgment. So I would take the daily rental value, which was also in the complaint. I would look at that, which I don't have it in front of me, but the daily rental value was $21.66 per day. So say our trial date was August 27th, just picking a date out of the air. We would calculate from August 1st to August 27th, so that's 27 days, times our $21.66 per day. So our holdover damages would be $584.82. I don't think I have my automatic calculations on here. So in this program, you can have automatic calculations turned on or off. So in this case, I want to turn them on. So it will total up my amount down here for the total judgment. Now, the plaintiff's also entitled to their court costs incurred, their filing fee, and their sheriff or process server fees. But our county won't allow us to fill this amount in here. We have to indicate. Let me get my cheat sheet here. Costs as awarded per CRC, California Rules of Court, 3.170 at SEC and following. And let's stop in the middle of this form and go to the memorandum of costs, which I don't think I even had listed. I apologize for that. But the memorandum of costs summary, which is form MC010. So this form, my county requires that I file the day of trial. They won't let me file it before that. And I put in there my process server fees and my filing fees. My process server served this for $48 to serve the named defendant and $48 to serve the PJ for unnamed occupants. And this information could be obtained off a copy of the filed proof of service. because that's where the sheriff or process server has to put that information on the proof of service as to the fees charged for the service. And then my total costs are $336. I fill out my proof of mailing on the back, again, filling in my business address, that I mailed it to the defendant, deposited in the mail. I mailed it to Joe, his address. Date of mailing, where I mailed it from. I date it and sign it. And again, that I file with the court the day of trial, and I mail a copy that same day to the defendant. So that's where I get the amount, but I cannot put it in there. But that's where the court will pick up on it at a later date, because costs are awarded. If you look at this form, this code, California Rules of Court, I don't even know if that's on the form. They used to let us fill them in, but no, can't see it. It's not on the form, but there's something about a 10-day period or something after a memorandum of costs is mailed out before the costs are added into the judgment. And I wish I could explain that better. Apologize that I can't. So the rental agreement is also canceled by the court. That's the, forfeiture there. If it was a lease versus a rental agreement, then you would say the lease is forfeited and it was still in the period of the, say, 1-year lease. And then you would check the box here because it's going to be signed by the judge or the court commissioner. And if I have the date of the trial, I'm going to put that date in here because the judge is going to sign it at the trial. So this judgment, when I sat down and prepared with the client the day or two before trial, I would have it all prepared. I would have copies made, and I'd have a sticky on it advising the plaintiff to give it to the bailiff for the judge when their case is called and they go up and sit at the table in front of the judge. Sometimes the landlord's never been to trial, so they need for you to give them an idea of how this is going to work. So I let them know they're not the only people in the courtroom. There's other people there for their cases, and they're going to be out in the audience until their case is called. And then they're going to go up and sit at the table in front of the judge, and the tenant's going to be at the opposite table in front of the judge. And it's at that time they want to make sure the bailiff gets that judgment to hand to the judge, because you want to advise the plaintiff too. They can't approach the judge. They have to hand documents they want the judge to see or to have to the bailiff to hand to the judge. Once the trial is over and the judge has signed the judgment, then my job the next day is to submit to the clerk the writ of possession, which we've already gone over how to fill that out, with the $40 fee to have it issued, and then take that issued writ to the sheriff with the instructions for the lockout. And the lockout in California is a statutory fee. The lockout fee that will be payable to the sheriff for the lockout is $145. Any questions on that? Okay. Your tenant's been locked out. You now know the date that they last had possession. And going back to Joe didn't file an answer, we did this all by default. We don't have a money judgment yet. Like if it goes to trial, you get your money judgment at trial. But if you've got your judgment for possession by default, then there are additional forms to submit to the court if your owner wants to go forward and get a money judgment against the plaintiff. So we're going to go over those forms. So again, we're going to pull up CIV 100, request for entry of default, only it's not going to be a for entry of default. It is going to be a request for a court judgment. The date you filed your complaint. Nope, we're not asking for a default. Yes, B, we are requesting a court judgment against the defendant, and you put their name. Here, under the demand for the complaint, we are going to ask for the money. So the demand in the complaint was the amount in the 3-day notice to pay, rent, or quit, $1,950. There's no credits. Then you go down to your costs, which my program actually fills in automatically. So let's go to page 2. We had our clerk's filing fee of $240 and our process server's fee of $96 for a total of $336 in court costs. When I go back to page 1, that's all been entered in there for me. No credits. Daily damages were demanded in the complaint at $21.66 per day, beginning August 1, 2020. Those amounts and dates appear on page 3 of your complaint, where we put in the daily rental value, and in the prayer of the complaint, we ask for damages from August 1st to the date of judgment. Again, we have to check on this form that we are either a legal document assistant or an unlawful detainer assistant. It's dated, signed by the plaintiff. Filling in my information here. You have to mail a copy of this to Joe. Now, Joe's already been evicted from that property, but we don't know where he moved to. So to his last known address, which would be the 1891 School Street in Anderson. Dated, signed by Tammy. And then we have our memorandum of cost there. That's dated, signed by Tammy. And fill out your declaration of non-military status again. And that's our request for a court judgment. The next document you do with that is a declaration for default judgment by court, which is Judicial Council number UD 116. That's what that looks like. Put your info up there. My name is Tammy. I'm the plaintiff in this action. I am a manager of the property. Normally it'd be an owner. I personally know the facts stated in this declaration, and if sworn as a witness could testify competently there too. So this is a written declaration in lieu of personal testimony. This is in lieu of the plaintiff having to go stand in court at a hearing in front of the judge to testify as to all this in order to get a money judgment. Because remember, this is in the event of a default, so we did not have a trial in front of the judge. So the agreement was written on or about July 27th, 2017. Defendant Joe Tennant agreed to rent the property for a month-to-month tenancy. He agreed to pay rent of $650 monthly, and the rent was due on the first of the month. Now here you need to attach the original agreement. And if you cannot attach the original agreement, because it's all the landlord has is a copy. You can check C, but then you have to do extra paperwork to have the copy admitted as if it was an original. I don't know. But that rarely comes up, so I don't have forms up here to show you all that. But if you ever run into that, call me, I will help you. If the agreement was changed in any way from the time it was entered into in 2017, say the change in the rent, you would check 5 and indicate that here, indicate that the rent was changed from $650 to whatever amount it was increased, and when that became effective, and whether it was made by agreement of the parties and the subsequent payment of such rent, or whether the plaintiff did it what I would call the right way and served an actual written notice of change in the terms. If it was by that, your original rental agreement should also have a copy of that written notice of change in terms. So that's the various ways that the agreement could have been changed over time. And again, that will depend on each case. In this case, there was no changes. Page 2, the defendant, Joe, was served with a 3-day notice to pay rent or quit because he got behind 3 months. The 3-day notice demanded rent in the amount of $1,950, which, looking back at your 3-day notice, began on May 1st and ended on July 31st. So May, June, and July, 3 months. D, the original or a copy of the notice specified in 6A was attached to the original complaint. You have to indicate how the notice was served on the defendant. Joe was personally served on July 30th. And a PJ, prejudgment claim of right to possession, was served on the occupants, so we check that box. The proof of service of the notice, an original or a copy, is attached to the original complaint. That's Exhibit 3 on our complaint. The notice was Exhibit 2, and our written rental agreement was Exhibit 1 on the original complaint. The fair rental value is $21.66 per day, calculated as follows. I do B, the monthly rent divided by 30. Possession, the defendant vacated the premises on, say the lockout date was September 4th. Holdover damages. Damages demanded in the complaint began on August 1st. Again, that's in your prayer of the complaint on page 3. The date damages commenced, which we determined by the fact that the 3-day notice only asked for rent through July 31st. So we want to capture the remaining rent owing from August 1st through the date when they moved out. Damages accrued through the date of the lockout, which was September 4th. And then you add up the total number of days. Now, it's assumed that every month is a 30-day month. So even though August had 31, I don't count 31 for it. I only count 30. So I would put 34 days there. And my program automatically calculates the 34 days times the $21.66 per day. Or if you're filling this out without using a program like this, you do your own math there. The court costs incurred in this case, including the filing fee, was $336. We got that back here off of the request for entry of the court's judgment in our memorandum of costs there, $336. Page 3 of the declaration, declarant requests a money judgment as follows. Our past due rent of $19.50, our holdover damages of, I can't remember what those were, so I'm going to go back here and look. 700, $736.44. I was going to try to copy and paste there, but $736.44, and our court costs of $336 for a total judgment of $3,022.44. None of this applies here because there was a clerk's judgment for possession, clerk's default judgment for possession already issued. So possession of the premises is not an issue now. They're out. We're just going after the default money judgment. You date it. Tammy signs it. And if there was a written rental agreement, your original rental agreement is attached and labeled Exhibit 4B. If there was a notice of change in terms of tenancy, that would be another exhibit here. But we don't have that in this case. Print it, have Tammy sign it, and then we do our money judgment. That's going to be submitted to the judge to be signed. So again, it's the same form. Judgment, Judicial Council Form UD 110. We put our information at the top. In this case, it's a judgment by default, but by court, being the judge. One, by default, but we do E, the court's judgment, and the court considered plaintiff's written declaration and evidence, which was this form here, our declaration in lieu of personal testimony. So we check E2. The rest of page 1 does not apply in this case. Page 2, judgment was entered by the court for plaintiff, Tammy agent, and against defendant, Joe tenant. Now my program fills this in, but I'm not going to check for because that is not an issue anymore. The defendant has already vacated the premises. He got locked out by the sheriff on September 4th. We're just going after our money judgment. So we go to 6, amount in terms of the judgment. Defendant named in 3A above must pay to plaintiff on the complaint the past due rent of $19.50. The holdover damages, again, I got to go back and look here. The $736.44. Our court costs of $336 for a total judgment of $3,022.44. So that amount there should match this amount here on the declaration. And the rental agreement is canceled, or if it was a lease that was still in the middle of its initial term, the lease is forfeited, and check the box for the judge to sign. Submit that to the court with your declaration for default judgment and your request for court judgment. The clerk submits the file to the judge reviews it all, signs your judgment, you get it back. Your plaintiff has his money judgment, which is good for 10 years.
Wow.
Any questions?
Yeah, I'm gonna ask the questions now, Debbie. I don't know how late you want to stay.
I'm okay.
Okay, we have quite a few. We'll try to get through all the questions. Anybody can check out at any time, and they can listen to the video later. So I'll start with the question that we had from Maria, and she wanted to know how successful is mediation in this process. The courts are requesting to go through mediation initially. So
I have no experience with mediation in unlawful detainer actions. Now, sometimes when one of my clients goes to a trial with a tenant in court, they will make a stipulation. You know, the tenant can stay until such and such a date if they paid this much money. But that's my only experience there. I have no experience with mediation in evictions.
Lisa says I would too. I'm not sure, maybe that she's talking about mediation. Jim Hildreth said CALDA is talking about a class on mediation. Yeah, Tracy and I talked about that this morning, and we're gonna be doing trying to get some of that going, possibly for the, when we do our conference, we'll do some mediation, or maybe we'll do a separate class we haven't done in it. How our answering does added to the case. I'm not sure what that means.
How much time does it add to the case?
Maybe that's what it means. How is answering? I'm not sure. Probably, and then the next, it looks like somebody answered probably through the prejudgment claim of right of possession. So I'm a little
Not
bit.
sure what those questions mean.
Yeah, I'm not sure.
Right.
You did say that people could contact you directly if they had any questions later on down.
Yeah, but probably you shouldn't try calling me. Send me your questions by email.
Okay. So get on CalDA website and get Debbie's.
Maria has her hand raised.
Well, let's try to get through the questions first.
Okay.
If you're not doing eviction, what's keeping you busy? Well, I'm not sure that's on point here. Just
No.
curious. I guess we're all doing what we could do.
I'm doing a lot of trusts and probates and trust administration and
Yeah,
guardianships, conservatorships,
I'm doing lots of divorces. People
lots of deeds.
Oh, see.
I'm referring all divorces to some of the other LDAs in town because I don't even have time to do any of that anymore. And I've kind of disconnected from family law because after years and years, I was just emotionally exhausted. So.
Jim Hildreth says lots of mediation for me. I'm not sure what that means, but
Yeah,
we'll
maybe
talk
he
to you.
can help tenants and landlords work it out so they don't have to do evictions.
Oh yeah,
Work
maybe
out
that's what he's
repayment
talking about.
plans and things like that. Yeah.
A mediation class would be wonderful. I've been doing tons of family law stuff. May either a sheriff or attorney service serve the writ of possession.
The sheriff.
May either a sheriff or attorney service serve a writ of possession. The sheriff has to do it.
I believe the sheriff has to do it because
Okay.
they scheduled the lockout time and it's only the sheriff who can go back to do the lockout. An attorney service can't. So, yeah.
Okay. If you dismiss the case, does it not show as an eviction on the defendant?
Well, if you dismiss the case, there's still going to be a record of the case having been filed there, but it's going to show that it was dismissed and didn't go to a judgment. And I believe I've been told with regard to civil cases that it doesn't hit someone's credit report unless a money judgment is entered. So say a landlord files an eviction and just takes it to the point of a clerk's judgment for possession only. They don't have me do the additional paperwork to get a money judgment because they believe they'll never be able to collect it. So why spend more money? But I don't know that for positive. But it's my understanding that a case like that will not hit someone's credit report unless there's a money judgment in it.
From Maria, it says TJE, LDA/UDA can serve as well, question mark?
What's a TJ what?
TJE, I'm not sure what that means,
Me neither.
but she said LDA, UDA can serve as well. So I assume that you could serve the documents?
I could serve the summons and complaint as a person who's 18 years of age and not a party to the action if there was no PJ being served.
Okay, Marianne says, please review again. Not sure what that means, maybe about service. If you live in the same address, can you file a different address to receive mail so tenant won't withhold landlord's mail?
Of course.
Okay.
You can use whatever mailing address you want.
From Angela, it says effective January 1st, 2020, Civil Code 1946-2 and 1947.12 are contained within the Tenant Protection Act of 2019, provided for eviction protections. Landlords are required to provide just cause prior to evicting tenant. Well, Angela always has good stuff.
Right, that's some of the laws that just went in effect right before this pandemic. And I did provide some information in the handout materials for the last class about those changes, just to give you what I had on it. So again, if it can be determined if that can be accessible by everyone, that would be great off the CALDA website.
Okay, and Yvette wrote, meant both parties live at the same address, and I think you did address that.
Yeah.
Okay, for Maria, what are the most expected results from this process? Hopefully to get the tenant out and get the money.
To get the tenant out of possession of the property so they can, re-rent the premises to someone who will pay the rent.
Right, okay.
That's the best case scenario.
From Angela again, if local ordinance limits evictions and provides greater tenant protection than this law, the local law protection would control instead of this law. Landlords must state the reason for the eviction on the eviction notice itself. The new law only limits evictions where the tenant has done nothing wrong, but the landlord wants to evict anyway. More details listed on, and she gives a website. And I think Tracy's going to do something about getting everybody the questions on the chat list here that will show all the websites that people have given us, so we can look up what they're referring to, like with what Angela just said. Okay, Robert, are the LDA or UDA costs recoverable? If so, where on the memorandum do you enter them? I think you covered.
Our court will not allow my fees to be included as part of the money judgment.
Okay, can the plaintiffs recover the fees they paid for your services?
No, not in this county. Not in this. Now they might try to, maybe they're going to take it out of the security deposit. Maybe they're going to take the tenant to small claims court after the fact to try to collect that and any damages to the property over what the security deposit covered. But as a part of the unlawful detainer action, our county does not allow the fees that I charge people for preparing their documents to be included as part of the money judgment.
Okay, they time to object to the memorandum of costs. If they do not file an objection by the statutory date, the clerk may enter the costs in the judgment. I
Yes.
think.
Yes.
Okay. Okay, when there is no trial after you file writ with sheriff for eviction, do you then file memorandum of costs and judgment to get back rent and damages?
You would file the last three forms we just went over. Okay. The request for entry of court judgment, the declaration for default judgment by court, and the judgment by court.
Okay, and then Robert just said he's sorry. I guess he had a typo, and he said the defendants have time to object to costs.
Yeah.
Okay, to ask for these fees of memorandum of cost, does it have to be asked in the complaint?
Well, your court costs are requested in your complaint on page 3 of the complaint under what I call the prayer of the complaint, where the plaintiff requests, possession of the property, and then it requests costs incurred in this proceeding. Those are your court costs.
Okay, Maria's asking, so the defendant is the one paying for the court and legal costs?
The money judgment against the defendant will include the court costs the plaintiff incurred, the filing fee, and the process server or sheriff's fee for serving the summons and complaint.
Okay, from Julia, you keep outing Tammy agent on the declaration of mailing. Is this correct? I'm not sure what that means. The plaintiff?
The forms I'm filling out are for the plaintiff, and the plaintiff's required to have copies mailed to the defendant, not to herself.
Does the court accept signatures by DocuSign, and do you charge extra for judgments?
Okay, that's two different questions. Our court will do, they call them fax filings here. Sometimes I've done evictions for landlords I've never met face to face. I've just talked to them on the phone. We do everything via the internet. I scan all of the documents I've prepared to them with places indicating where they need to sign. They sign, scan, and email everything back. And then I have to indicate on the face of the document that it's filed by fax. And I have to attach to it a form indicating I'm a fax filing agent. What was the rest of that question?
Oh, I was kind of going ahead to try it.
Sorry.
That's okay. Something about judgment. Oh, do you charge extra for judgment?
Oh, I see. If we get the clerk's judgment for possession by default, I do charge an extra fee for doing the additional documents to get a money judgment. Yes, by default.
Okay. Yes, we'll be providing a video of the seminar. We're going to try to do a tenant response.
That's good. I will attend.
You will?
I will. I will attend to learn. Yes. Just that I haven't done that much of those forms.
Just to answer Diane's question, yes, the screen will appear in the recording. And Maria, we're going to take your question at the end because we have 50 new messages that have come in.
Yeah, we have 73. Are judgments renewable?
Yes. There are judicial council forms for renewing a judgment, but it does need to be done before the 10 years expires. So, you know, if someone wants to renew a judgment, they should calendar to get started on that several months prior to the 10 years expiring.
Julia says, does like does 1 through 10? Yes. Do judgments collect 10% interest?
Yes.
What happens when the tenants just can't pay?
They get evicted.
Yeah, I guess
I'm not sure what that
all this is
question
about.
was. Yeah.
Okay. Do you handle post judgments, and what is an estimate that landlords usually collect the money owed?
It's a very small percentage of landlords that ever collect their money owed. I've had a few. Yes, I do post judgment work, collections.
Okay.
Okay,
sorry.
But it's very limited. A very small percentage that ever collect their money back.
Okay. Does CALDA offer classes on post judgments? We can always put that on our list to consider. Any suggestion for collection agencies that can work on this?
I have no suggestions. I don't know if anyone else does. They should share that on the chat if they do.
Okay, let's see. Does tenant forfeit deposit in cases like this when tenant is locked out of property?
No, the landlord is still required under the code section within 21 days of getting possession of the property back to send out by mail to the defendant's last known address a security deposit transmittal outlining how the security deposit was used and refunding any unused amount or indicating if there's more owing. The landlord still has that responsibility.
What happens in your experience when the tenant moves out before the default judgment?
We dismiss the unlawful detainer case.
And then do you initiate a small claims action to collect past rent?
That would be up to the plaintiff.
What is the
It's
process?
even collectible. I mean, how can you collect from people who can't even pay their rent? They're usually not working, they're unemployed, they've lost their job or you know, a myriad of different reasons there, but it's like, My mom always said, how do you get blood out of a turnip, you know? It's just you.
Yeah, that's what this
How are
begins.
you going to get that money if they can't even pay their rent? How are you going to collect? Even if you do you know where they work and you do a wage garnishment to try to collect that money judgment, it won't be too long usually before they quit that job and go on to another. It's just a very hard area to collect money judgments in. Yeah.
What is the process of you attain a money judgment to note the tenant's bad credit or eviction?
Well, again, if you get a money judgment in an unlawful detainer action, it's my understanding that will show up on their credit report.
Okay, it says, who do you contact, credit bureau, and how? But
Well, I think the credit bureaus, they keep an eye on the courts. That's my understanding, and they pick this information up from the courts. I don't think that the plaintiff has to report it anywhere. It's just something that happens. Like if you got a money judgment entered against you, say you got behind on a credit card and they sued you, the credit card company, and they got a money judgment against you, that's going to show up on your credit report eventually. And it's not because the plaintiff reported it. The credit reporting agencies pick this stuff up. Is how I understand it works.
okay, let's see. On serving a 3-day notice to quit, if notice does not include election of forfeiture, will you need to serve a 3-day notice with correct verbiage?
I would serve a brand new notice done correctly.
Okay,
Yeah.
Have you inquired with the court whether the landlord could recover the costs of your services if you're registered UDA rather than an LDA?
No, I have not directly inquired.
Okay. I believe Chris, attorney, might do tenant response now. Can you do a lien or levy for UD money judgments?
A UD money judgment's the same as any other money judgment in the courts. You can, there are various means of collecting it. You could do an abstract judgment and record that. And that way, if the defendants who had the judgment against them ever bought or sold real property in the particular county you recorded that abstract in, that lien would pop up and you would get paid out of any escrow. You can garnish wages, you can do bank levies, you can levy on certain personal property. There's a lot of options for collecting judgments, but an unlawful detainer judgment is the same as any other kind of money judgment.
From Robert, I have a company called Collins Judgment Recovery Service. He leaves his website and his phone number. You can go on the
That's a good contact to have, yeah.
Can you garnish wages with the money judgment can you garnish wages with the money judgment?
Yes, if you know where the judgment debtor works.
Yeah. When do you handle wage garnishment assignments?
When someone calls me and hires me to do one.
Okay. Jim Hildreth says, thanks, Debbie Driver. On behalf of all, you did a great job. Something else so much. Can they expunge the money judgment by filing for BK?
Oh, that I don't know a lot about bankruptcy law, but I'm sure that would expunge it.
Okay. Another thank you. Great class.
Just stick with the questions because there's a lot of thank yous in there.
Yeah. If the case gets dismissed, is it still reported on the UD or the YUDI report? I'm not sure.
No, it would not show up on a credit reporting agency unless a money judgment was entered in the case.
Can you go over the abstract? You can file a little more in detail. That's from Alexis.
That would be more for a class on collections. It's just a judicial counsel form and you have to fill out the date the judgment was entered and the amount of the judgment. Then it's issued by the court, and you take that issued abstract to the recorder's office, put a cover sheet on it, and pay the recording fee to record it. The judgment creditor would have to tell you what county or counties they want that recorded in, because it's only puts a lien on any real property in whatever county you record it in. It doesn't cover the whole state of California.
Raymond wrote, expunge would not be the term, but it would be canceled.
Oh, if they filed bankruptcy, right. But their bankruptcy would show up on their credit report for like 10 years or something.
Tracy, did you see Diane's question about the probate webinar?
Yes, the probate webinar is up online in the members section. Oh, actually, you know what? That is a CalDA Academy. If you need, if you signed up for the probate webinar and you need a copy of it, please contact me, membership.admin@calda.org, and I will get it to you.
Okay. Alexa said I skipped a question. Can you recoup LDAUD fees from security deposits?
I believe so.
Phone number for essential forms. I think they can just go online and get that.
I was going to try to put that back up here.
Okay.
Just share. And there you go.
Okay.
Oh, it's paused again. Why does it do that?
I don't know, you're not sharing. Yeah.
Let me speak it. It's 1-800-232-3444. Okay.
Okay. From Robert, seems like judgment should be treated like an intentional tort which cannot be canceled. Thank you to whoever answered the BK question.
Yes, thank you.
I'll have to ask my friend who does bankruptcy.
Yeah.
I don't think you can, I don't know, I'll have to ask.
So we are at noon, and I want to thank Debbie for coming and teaching. Debbie, would you be able to stay on for a couple more minutes? We'll end the recording, but Maria can ask her question, and anyone else that has a follow-up maybe with you could speak, and we'll go from there.
Yes.
Okay, I'm going to go ahead and end the recording, and go.